Can a guardian move a ward out of state? Have you ever wondered what happens when a guardian wants to move their ward to another state? This is a common question in the realm of elder law, especially when it comes to protecting incapacitated adults. Let's break down the process and what you need to know. First off, a guardian can indeed move a ward out of state, but it is not as simple as packing up and leaving. Legal procedures must be followed to ensure that the ward's best interests are taken into account. The guardian must first obtain permission from the court that appointed them. This step is essential to make sure the move is legally authorized and that the ward's welfare is prioritized. Most states have adopted the Uniform Adult Guardianship and Protective Proceedings Jurisdiction Act. This act provides a framework for transferring guardianship between states. Under this act, the ward must be permanently relocating, and the move should not harm their interests. Additionally, there should be no objections from interested parties, such as family members. The guardian must also have a solid care plan for the ward in the new state. Communication is key in this process. Guardians are required to notify close relatives and other interested parties about the proposed move. This allows anyone who may have concerns to voice their objections. If there is opposition, the court may hold hearings to discuss the matter further. To transfer guardianship, the guardian typically needs to file a petition in the original state's court. This petition requests the transfer of guardianship to the new state. Once the court issues a provisional order, the guardian must file this order in the new state. This may involve additional steps, such as hearings or registrations, before the new state recognizes the guardianship. It is important to remember that each state has its own rules regarding guardianship and may implement the Uniform Adult Guardianship and Protective Proceedings Jurisdiction Act differently. Some states may require formal registration of the guardianship order, while others may need a new guardianship proceeding. Consulting with an attorney who specializes in elder law can help navigate these requirements. Throughout this entire process, the focus remains on the best interests of the ward. This includes considering their health, safety, and access to appropriate care. Moves that are motivated by convenience or family disputes, without regard for the ward's welfare, may be denied. If the move is within the same state, the guardian may only need to provide notice to interested parties and obtain court approval without transferring guardianship. However, for out-of-state moves, transferring or registering guardianship is essential to maintain legal authority. Guardians should also prepare documentation about the ward's care plan in the new location. Compliance with all court orders and state laws is crucial to avoid losing guardianship or facing legal challenges. In summary, a guardian can move a ward out of state, but it requires careful planning, court approval, and adherence to legal procedures to ensure the ward's rights and continuity of care are protected.